Thank you for having me here. My topic today is actually the role of a dispute resolution in enhancing the industrial sector. I mean, there's no cavil about it that we have been discussing for over 20 years now. What is the role of DR in otherwise helping in bringing back the confidence of the investor and in helping to actually expand the industrial base? What is the punchline? Is it how effective should be the role? There are a couple of factors which I need to discuss. We have infrastructure, we have laws, we have mediation, we have boards, we have arbitration, we have other infrastructure. But what we lack is we need to influence the thinking actually. This entire conference, the efforts to persuade people to resort to mediation, arbitration, or other dispute resolution mechanism is actually to facilitate a common man, a person, a client in the context of a lawyer. Now, the most important part is I've been practicing at the bar. The most problematic issue is whenever a client comes to you, they would never actually speak out the true facts. That actually is the problem, because unless they speak out true facts and bring the complete fair picture before you, you cannot actually advise them to an arbitration or so whatever the mechanism would be, unless we influence the thinking of a subject, which is a person who is actually raising a dispute, we can't make an effective inroads into this. The second is the role of the judiciary. I think I've been hearing for so many of participants, judiciary has never actually discouraged mediation, arbitration, or any other enforcement of a dispute resolution mechanism. They've already encouraged that. The only problem is that what we need to distinguish is that judicial inclination to facilitate mediation or arbitration is one thing, and the availability of time and resources to deal with the disputes another thing. I think what we need to do is we need to concentrate on the latter. It's only a question of time that what we lack is in deciding a commercial dispute or commercial or any other dispute. Now, over the decade, I think judiciary has been showing restraint in involving in a pre-tendering dispute, post-tendering disputes, issues regarding mobilization advance guarantees, issues regarding performance bonds. I think that is an efficient participation of a judiciary to actually persuade the parties to come to resolve their disputes. Now, one cannot actually eliminate a role of a judiciary. Judiciary has to play a role of a big brother actually, which has to supplement and support the effort of this dispute resolution mechanism. And perhaps what I think is we always encourage this alternate dispute mechanism should prosper actually. And I think, speaking for myself and all other judges, our work is evident in terms of the judgments available. And as we have, most of the judgments have been referred, they are always for the pro-enforcement. I mean, it's very encouraging that the foreign international awards are being enforced quickly now. I have a slight difference, The difference is that we have criticized the Arbitration Act 1940. What I think is law is not a bad or a good actually. It's how you enforce that. And the enforcement problem is actually with the courts exercising general jurisdiction. It's not the courts exercising special jurisdiction actually. What we need to do is to make it clear to a civil judge actually that everything does not come within the ambit of Section 9 suit. There are other laws and it has to be respected. So if a suit is filed, the mechanism is available, Section 34 applies to that. But how he looks at it and how he applies, that's the question actually. I agree with that, there's a lot of, delay in deciding application under 34, application under section 20. But then, even if we look at the Arbitration Act across the globe, judicial intervention is there to an extent. So what we need to understand is that judicial discretion, judicial intervention is there, but it has to be exercised cautiously. And one more thing I want to add is that we have discussed a lot about it, this mechanism, laws, judiciary, lawyers. What we need to understand is, yesterday there was a discussion that lawyers should actually encourage mediation. What we need to think is, we need to actually draw a distinction between lawyers sitting, having an office in a Clifton, lawyer having an office across the High Court in E. Plomer building, and a lawyer who is actually doing practice in Bahawalpur, who is actually doing practice in Multan, in Jakpabad actually. I mean, a lawyer working in Bahawalpur will charge the fee for a family suit, say about 50,000. You expect the lawyer to advise his client to go mediate and give up 50,000 rupees. I mean, it's quite easy for me to sit in a chamber in Lahore and refuse a family matter, because I know I have no time for a family matter. But lawyer sitting in Bahawalpur would not refuse that brief. So I think we need to keep that context in our mind while making all these efforts in it. Thank you.